In the digital age where communication platforms like WhatsApp have become integral to personal and professional interactions, the legal system is grappling with how to handle digital evidence. In 2025, the Delhi High Court delivered a series of landmark rulings that have reshaped the landscape of electronic evidence in India, particularly concerning the admissibility of WhatsApp conversations in court. These decisions, alongside the court's broader push for digital justice through the Electronic Evidence and Video Conferencing Rules, 2025, signal a pivotal moment in India's judicial evolution. This article dives deep into the Delhi High Court's WhatsApp evidence rulings, their legal foundations, implications for the judiciary, and their impact on everyday citizens, legal professionals, and businesses navigating India's legal system. In July 2024, the Delhi High Court, in the case of Dell International Services, India Private Limited vs. Adil Feroz, 2024, DHC 4954, set a significant precedent by ruling that WhatsApp conversations cannot be admitted as evidence in court without a proper certificate as mandated under Section 65B of the Indian Evidence Act, 1872. This case involved Dell challenging an order from the Delhi State Consumer Dispute Redressal Commission, which had rejected Dell's written statement due to late submission. Dell attempted to use WhatsApp chat screenshots to prove it had not received complete complaint documents on time. However, Justice Subramoniam Prasad held that these screenshots were inadmissible without Section 65B certification, which requires a certificate to verify the authenticity and reliability of electronic records. Section 65B mandates that electronic evidence, such as WhatsApp chats, must be accompanied by a certificate affirming that the record was produced by a reliable computer system and accurately represents the information contained within. The court emphasized that without this certification, WhatsApp conversations lack legal validity as they could be manipulated or lack context. This ruling reinforced procedural rigor, ensuring that electronic evidence meets strict standards to maintain judicial integrity. The court also noted that Dell failed to present these chats before the State Commission, further undermining the admissibility in a writ petition under Article 226 of the Constitution. In May 2025, a Delhi court, in a significant development related to the 2020 Northeast Delhi riots, further clarified the role of WhatsApp chats in criminal cases. The court acquitted 12 accused individuals in 5 murder cases, ruling that WhatsApp chats from a group named Kattar Hindu Ekta could not be treated as substantive evidence, but only as corroborative material. The Delhi police had relied heavily on a message allegedly posted by one accused, Lokesh Solanki, claiming he had killed 2 Muslim men. However, additional Sessions Judge Pulastya Pramachala noted that such messages could be exaggerated or false, posted to gain status within the group, and thus lacked reliability as primary evidence. The court's reasoning highlighted the limitations of WhatsApp chats in criminal prosecutions, where the burden of proof is high. Without corroborative evidence like eyewitness testimony or physical proof, such chats were deemed insufficient to establish guilt. This ruling underscored the need for a cautious approach to digital evidence in sensitive cases, particularly those involving communal violence, where 53 people died and over 500 were injured in the 2020 riots. Of the 109 judgments related to the riots by February 2025, 82% resulted in acquittals, often due to hostile witnesses or weak evidence, further emphasizing the judiciary's stringent standards for digital evidence. In contrast to the restrictive stance on WhatsApp as evidence, a July 2025 ruling in Belvedere Resources, DMCC vs. OCL Iron and Steel Limited and Oz, marked a progressive step. The Delhi High Court ruled that WhatsApp and email exchanges could constitute a valid arbitration agreement under Section 7(4)(b) of the Arbitration and Conciliation Act, 1996, even without a signed contract. This case involved a UAE-based company, Belvedere Resources, seeking monetary security of 23.34 crore rupees after a coal supply agreement with Indian entities fell apart. The negotiations, conducted largely via WhatsApp and emails, included confirmations of commercial terms and dispute resolution provisions. The court held that electronic communications demonstrating a meeting of minds could satisfy the requirements of an arbitration agreement, reflecting the realities of modern business practices. This ruling aligns with the global trend of recognizing digital platforms as legitimate mediums for contractual agreements, particularly in international trade. However, the court dismissed the plea for interim relief, citing insufficient evidence of attempts to obstruct execution, balancing flexibility with procedural caution. On July 4, 2025, the Delhi High Court notified the Electronic Evidence and Video Conferencing Rules, 2025, a landmark framework to integrate digital tools into judicial proceedings. Effective from July 9, 2025, these rules grounded in Articles 225 and 227 of the Constitution, the Delhi High Court Act 1966, and the Bharatiya Nagrik Suraksha Sanhita (BNSS) 2023, grant full legal validity to electronic evidence and video conferencing in trials, inquiries, appeals, and witness examinations. The rules mandate the use of government-approved, encrypted video conferencing platforms and establish protocols for digital authentication, real-time coordination, and technical support to ensure procedural integrity. This framework complements the WhatsApp evidence rulings by providing a structured approach to handling electronic records, including chats, emails, and digitally recorded testimonies. It addresses long-standing concerns about the reliability of virtual courtrooms, making justice more accessible and efficient while upholding fairness. Legal experts view these rules as a milestone in India's digital justice mission, aligning with the digitization goals of the BNSS and the Bharatiya Sakshi Adhiniyam 2023. The Indian Evidence Act 1872 governs the admissibility of evidence in Indian courts. Section 65B, introduced to address electronic records, requires a certificate to authenticate digital evidence, ensuring it is produced by a reliable system and accurately represents the original data. The Delhi High Court's 2024 ruling in the Dell case reiterated this requirement, aligning with prior judgments like Rakesh Kumar Singla versus Union of India, 2021, by the Punjab and Haryana High Court, and M.S. Karuna Abhushan Private Limited versus Sri Achal Kedia, 2020, by the Delhi District Court. These cases emphasize that WhatsApp chats, despite their widespread use, must meet strict procedural standards to be admissible. The requirement for Section 65B certification addresses concerns about the authenticity of digital evidence, given the ease of manipulating screenshots or chats. For instance, in the Dell case, the court noted that WhatsApp chats presented without certification could not be considered, especially in a writ petition where procedural fairness is paramount. This ruling sets a benchmark for future cases, compelling parties to ensure proper documentation and certification when relying on electronic evidence. The WhatsApp evidence rulings intersect with broader debates about privacy and fair trial rights. In a separate 2025 case, SMT. Anjali Sharma versus Raman Upadhyay, MP No 3395, 2023, the Madhya Pradesh High Court ruled that WhatsApp chats obtained through surveillance, even without consent, could be admissible in family court proceedings if relevant to resolving matrimonial disputes. This decision prioritized the right to a fair trial over privacy concerns, citing precedents like R.M. Malkani versus State of Maharashtra 1973 and Sharda versus Dharmpal 2003. The court argued that in sensitive family matters, excluding relevant evidence due to privacy concerns could hinder justice. This ruling contrasts with the Delhi High Court's stricter stance on certification, highlighting a judicial balancing act. While the Delhi rulings emphasize procedural rigor to protect judicial integrity, the Madhya Pradesh decision reflects a pragmatic approach to digital evidence in personal disputes, where privacy often clashes with the need for truth. These differing approaches underscore the evolving nature of digital evidence law in India, as courts navigate the tension between technological realities and legal principles. The Delhi High Court's WhatsApp rulings also tie into ongoing privacy disputes involving the messaging platform. Since 2021, WhatsApp and its parent company, Meta, have challenged India's Information Technology, Intermediary Guidelines and Digital Media Ethics Code Rules 2021, which require social media platforms to trace the first originator of messages upon court order. In April 2024, WhatsApp told the Delhi High Court that it would exit India if forced to break its end-to-end encryption, arguing that traceability violates user privacy rights upheld in the Supreme Court's K.S. Puttaswamy versus Union of India 2017 judgment. The court acknowledged that privacy is not absolute and sought a middle path to balance traceability with user rights, postponing the case to August 2024. This debate complicates the use of WhatsApp chats as evidence, as encryption ensures that only senders and recipients can access messages, making certification under Section 65B critical for verifying authenticity. The tension between privacy and legal accountability remains unresolved, with implications for how courts treat digital evidence in the future. The Delhi High Court's rulings have far-reaching implications for litigants, lawyers, and businesses. For individuals, the requirement for Section 65B certification means that WhatsApp chats, often used informally in disputes, must be meticulously documented and certified to be admissible. This is particularly relevant in consumer disputes, family law cases, and criminal prosecutions, where digital communications are increasingly common. For example, in matrimonial disputes, WhatsApp chats are often pivotal in proving allegations like cruelty or infidelity, as seen in the Madhya Pradesh case. Lawyers must now prioritize obtaining Section 65B certificates when presenting electronic evidence, which may involve technical expertise to ensure compliance. This requirement could increase litigation costs and complexity, particularly for individuals unfamiliar with legal procedures. However, the Electronic Evidence and Video Conferencing Rules, 2025, streamline the process by establishing protocols for digital evidence collection and authentication, potentially reducing barriers for litigants. For businesses like Dell, the 2024 ruling underscores the importance of timely and accurate record keeping. The rejection of Dell's uncertified WhatsApp chats highlights the risks of relying on informal communications without proper documentation, urging companies to align with legal standards. The Electronic Evidence and Video Conferencing Rules, 2025, complement the WhatsApp rulings by modernizing India's judiciary. By granting legal validity to digital proceedings and evidence, these rules reduce logistical burdens, such as the need for physical appearances, and make justice more accessible, especially in remote areas. The use of encrypted video conferencing platforms and designated coordinators ensures security and procedural fairness, addressing concerns about hacking or unauthorized access. These reforms align with India's broader push for digital justice, as seen in initiatives like Kerala's online permanent Lok Adalat, launched in 2025. The Delhi High Court's rules also support the Bharatiya Sakshi Adhiniyam 2023, which updates evidence laws to accommodate digital advancements, ensuring that India's legal system keeps pace with global trends like the 96% adoption of AI in UK law firms. The WhatsApp rulings resonate with the public, much like the Nimisha Priya case, which captured attention due to its human stakes and international legal complexities. The requirement for certification protects individuals from misuse of manipulated digital evidence, such as fabricated WhatsApp chats in personal or criminal disputes. However, it also raises accessibility concerns for marginalized groups who may lack the resources to obtain technical certifications. The Northeast Delhi riots case illustrates the societal impact of these rulings. The acquittal of 12 accused due to the unreliability of WhatsApp chats as substantive evidence highlights the judiciary's cautious approach in high-stakes cases, preventing potential miscarriages of justice. Yet, it also underscores the challenges of prosecuting communal violence, where witness hostility and weak evidence often lead to acquittals, fueling public debate about justice and accountability. The Delhi High Court's rulings signal a need for legislative and judicial reforms to address the complexities of digital evidence. The ongoing WhatsApp Meta challenge to the IT Rules 2021 may prompt the government to clarify traceability requirements without compromising encryption, potentially influencing how WhatsApp chats are authenticated under Section 65B. Additionally, the Electronic Evidence and Video Conferencing Rules 2025 could inspire other high courts to adopt similar frameworks, standardizing digital evidence practices across India. Legal experts suggest that future reforms may include simplified certification processes for electronic evidence, making it easier for individuals to comply with Section 65B. Training programs for judges and lawyers on digital evidence handling could also enhance judicial efficiency. Moreover, public awareness campaigns could educate citizens about the legal requirements for using WhatsApp chats in court, bridging the gap between technology and law. The Delhi High Court's WhatsApp evidence rulings in 2024 and 2025, coupled with the Electronic Evidence and Video Conferencing Rules 2025, mark a transformative moment in India's legal landscape. By enforcing strict certification standards for WhatsApp chats, the court ensures judicial integrity while adapting to the digital age. The contrasting approaches, restrictive in consumer and criminal cases, progressive in arbitration, reflect the judiciary's effort to balance procedural rigor with modern realities. These rulings, much like the Nimisha Priya case, highlight the intersection of law, technology, and human stories, captivating public interest and shaping the future of justice in India. As WhatsApp remains a cornerstone of communication for over 900 million Indians, these decisions underscore the need for clarity, accessibility, and fairness in handling digital evidence. Whether you're a litigant, lawyer, or citizen navigating the legal system, the Delhi High Court's rulings serve as a reminder. In the digital era, justice demands both innovation and accountability. Stay tuned for further developments as India's judiciary continues to evolve in the face of technological change.